Hello. Welcome to my channel, Shirley TV. So, welcome to my channel. So, I woke up this morning and I was like, here we go again. Here we go. What? Famed and beloved Jamie Foxx accused in this new lawsuit. This lawsuit was filed November the 20th. November the 20th, 2023. So Mr. Jamie Foxx. So what they said, Eric Marlon Bishop, aka Jamie Foxx, never knew his real name. I thought his name was Jamie Foxx. So I guess you do have different names that you can use. So aka Jamie Foxx. So Eric Martin Bishop, aka Jamie Foxx. So let's get into this new lawsuit. So I did a video on the Puffy Combs lawsuit. Puffy Combs and Cassie Ventura. So I did a video on that, and I did go over the lawsuit, in there. I went over the lawsuit, the copy of the lawsuit in their case. But their case has since been settled. So then I woke up this morning. I said, it's Thanksgiving morning. I want to say happy Thanksgiving to everybody. Thank you for being here. Glad to see you. Glad you can join me. Happy Thanksgiving. And first of all, I want to give honor to God. And I want to say, God, thank you for all my many blessings, my family, my kids, my grandchildren. So I want to thank you, God, for all you have done for me in my life. Yes, and God, just keep blessing me. I love you, God. I love you, God. And so let me get into this lawsuit. So this is a civil complaint. So when it comes to civil complaints, we're dealing with money damages. So criminal. Most of the time in a criminal case, well, some of the time, I guess I would say, they're dealing with lockups. But lawsuits come through, civil lawsuits come through, money damages. So seeking money damages in these civil lawsuits. So let's get into this lawsuit. So this lawsuit was filed November the 20th, 2023 in the Supreme Court of the State of New York, County of New York. Jane Doe is the sole plaintiff. Jane Doe, the single sole plaintiff. So it is allegedly that these plaintiffs, Eric Marlon Bishop, aka Jamie Foxx, Catch New York City and Ruth, NYC and Ruth, Catch NYC Incorporated, Mark Birnbaum, Catch Hospitality Group. So I guess these are the businesses. This is the business, this Catch rooftop in New York City. So we have the Catch Hospitality Group, 25th 9th Avenue, that's the location, Corp LLC, California 21 to 27, 9th Avenue LLC, and John. So Jane Doe, so in other words, she is alleging that these 10 plaintiffs, so it says, said names being fictitious and intended for unknown names of staff of the other defendants. So let's get down into it. So we come down here, it says, this is a summons. This is the summons. Well, issued a summons. Plaintiff designates New York County as a place of trial. The basis of venue is location of incident. So we're looking at, it says, to the above named defendants. You are hereby summoned to answer the complaint in this action and to serve a copy of your answer, or if the complaint is not served with this summons, excuse me, to serve a notice of appearance on plaintiff's attorneys within 20 days. So The plaintiffs have to serve notice of appearance. You have to serve a notice of appearance on the plaintiff's attorneys. So she had more than one attorney within 20 days after the services of this summons, exclusive of the day of service, when service is made by delivery upon you personally, within the state, or within 30 days after completion of service, where service is made in any other manner. In case of your failure to appear or answer, judgment will be taken against you by default for the relief demanded in the complaint. So the defendants have to respond to this complaint. So it is a complaint. They have to file. So they have to answer this complaint. They have to have an answer. So it says to answer the complaint in this action and to serve a copy of your answer, or if the complaint is not served with this summons, to serve a notice of appearance on plaintiff's attorney. So they have to file their answer and make sure that the plaintiff's attorney receives their answer within 20 days after the services of the summons. So let's get into it. Let's get further into it. So these are the defendants: Eric Marlon Bishop, aka Jamie Foxx; Catch Restaurant, aka Catch New York City and Roof, 219 Avenue, that's in New York; Catch NYC Incorporated, aka Catch NYC and Roof, 429 Atlantic Avenue. Look like they had several locations, because they have it's 21 9 Avenue in New York, New York. And then we have 429 Atlantic Avenue. Oh, it said Catch Restaurant and Catch Incorporated. Okay, then Catch NYC Incorporated, aka Catch NYC and Roof, Airy Covant, 15 East 32nd Street. Then we have Catch Rooftop, aka Catch New York and Roof. And then we have Catch Hospitality Group. And then we have Mark Birnbaum, company of Catch NYC and Roof, 25th 9th Avenue Corp. LLC, company of Deanna Durso, 15 Colony Lane. This is Manhasset, New York. Then we have California, 21 to 27 9th Avenue LLC. This is 1407 Broadway, 41st floor. 41 floors, New York, New York. And it says, this is a copy of a pleading filed electronically pursuant to New York State court rules. So I'm reading the red print, which at the time of its print out from the court system's electronic website had not yet been reviewed and approved by the county clerk, because court rules 22 NYCRR authorize the county clerk to reject filings for various reasons. Readers should be aware that documents bearing this legend may not have been accepted for filing by the county clerk. So in other words, the document may not have been accepted yet by the county clerk, but it looked like they made it public. So it can, in other words, this red print says it could be rejected. It said they authorize the county clerk to reject filings for various reasons. Readers should be aware that documents bearing this legend may not have been accepted for filing by the county clerk. So it might not be, according to this red print. And so let's get into it. It says verified complaint. This is a verified complaint. Supreme Court of the State of New York, County of New York. Jane Doe is the plaintiff. Against several defendants. Eric Marlon Bishop, aka Jamie Foxx. We have the Catch NYC and Roof, Catch NYC Incorporated, that's 2. Mark Birnbaum, 3. Catch Hospitality Group, 4. 25th 9th Avenue Corp. and John. plaintiff Jane Doe by her attorneys, law officers of Michael S. Lamonsaw PLLC. I don't know what PLLC is. As I know, these are attorneys, so I assume they're still attorneys at law. But it said PLLC. I have to find out what that abbreviation is. As and for their verified complaint. So this is a verified complaint through her attorneys. Alleges the following upon information and belief. Here go the parties. Let's get into it. That at all times relevant here to plaintiff Jane Doe was a resident of Kings County, state of New York. That upon information and belief at all times relevant here to defendant Eric Marlon Bishop, aka Jamie Foxx, was and still is a resident of Ventura County, state of California. So I've never been to California before. Never been to California, but I heard that you have to take a flight. You gotta take a flight. Want to take another flight? I just want to have a good night. So I like that song. Let's get back into it. What? So let me see. Number 2. Okay, am I on number 2? Oh no, I think I'm still on number 1. No, that was number 1. Here go number 2. That upon information and belief at all times relevant here to defendant Eric Marlon Bishop, aka Jamie Foxx. Well, okay, I think I read this. Was and still a resident of Ventura County, state of California. Let's go to number 3. What? On or about August 26, 2015, defendant Eric Marlon Bishop, aka Jamie Foxx, was at a restaurant and rooftop lounge and bar located at 21 9th Avenue, New York, in the city, county, and state of New York. So Mr. aka Jamie Foxx was allegedly at this restaurant August 26, 2015. So he is one of the defendants. He was at this restaurant. Let's get it going. Let's move on. Okay, let's go down. Number 4, that at all times relevant here to defendant Catch NYC and Roof, aka Catch Rooftop, was and still is a domestic corporation duly organized under and existing by virtue of the laws of the state of New York. And number 5, that at all times relevant here to defendant Catch NYC and Roof, aka Catch Rooftop, was and still is a foreign corporation duly authorized to conduct business in New York. So in other words, Catch New York City, NYC and Roof, they are. I guess I could say they are, So it says they was. It says, do it say they was? It says, and still is, right, they are. And still is a foreign corporation duly authorized to conduct business in New York. So they are a foreign corporation duly authorized to conduct business in New York. So let's go down to number 6. That at all times relevant here to defendant Catch NYC and Roof was duly authorized to transact business in the state of New York. So they are authorized to transact business in New York. That at all times relevant here to defendant, Catch New York City and Roof Top owned, operated, maintained, managed, and controlled the restaurant and rooftop lounge and bar located at 21 9th Avenue, New York. So I don't have to read all this. So it looks like it's the defendants, the restaurant. It looks like it's AKA Jamie Foxx, and it's the Catch New York City and Rooftop, AKA Catch Rooftop, New York City and Rooftop. Catch New York City and Rooftop, and Jamie, aka Jamie Foxx. So those are the named plaintiffs in this lawsuit. So I'm not going to read all this. Oh, and then also they have another defendant, Mark Birnbaum. So we have aka Jamie Foxx, Mark Birnbaum, and then we have the Catch New York City Rooftop. So I only see 3 in this lawsuit so far. So let me go on down, and it says that at all times, relevant here too, defendant Mark Birnbaum was under, excuse me, was under a duty to own, operate, maintain, manage, and control the aforesaid premises in a proper, safe, and lawful manner. Okay. Okay. Excuse me. So it seems like to me they're naming Mr. Mark Birnbaum as a defendant as well because he was under a duty to own. So he was the owner, I guess. He was under a duty. So in other words, they're suing the owner of this restaurant, Jamie Foxx, aka Jamie Foxx, and the owner of his restaurant. It says that at all times, relevant here too, defendant Mark Birnbaum was under duty to own, operate, maintain, and manage and control the aforesaid premises in a proper and lawful, safe and lawful manner. So in other words, you also have a duty of care. You know, you have a duty of care to your patrons, your customers that come in. So they didn't offer a safe environment for this, I guess I would say, plaintiff. Didn't offer a safe environment for the plaintiff, so she, I assume it's a female that's suing because I read some of the allegations, so it's a female. So they call the female Jane Doe, so we're going to stay with Jane Doe in this, this video. So in other words, it said that at all times relevant here to defendant Catch Hospitality Group was and still is a state domestic corporation duly organized under and existing by virtue of the laws of the state of New York. So let's keep it moving. It says, this seems like they're saying the same thing, but they're giving a different. What it says, look, that at all times relevant here to defendant Catch Hospitality Group was duly authorized to transact business in the state of New York. So in other words, they're saying that the first one they're saying is hospitality, but they said it 4 times. Hospitality Group was and still is a foreign corporation authorized to conduct business in New York. Then they're saying it again. The Catch Hospitality Group was duly authorized to transact business. So they're authorized to conduct business in New York, and they're authorized to transact business in New York. And then it says Catch Hospitality Group owned, operated, maintained, managed, and controlled a restaurant and rooftop lounge. So it still is a restaurant and rooftop lounge that Mr. AKA Jamie Foxx, he was allegedly present there in August 2015. So let me move on down. So I have to read all that. And then it says, okay, let me go to 27. That at all times relevant here to defendant 25 9th Avenue Corp. LLC was under a duty to own, operate, maintain, manage, and control the aforesaid premises in a proper, safe, and lawful manner. So in other words, the plaintiff is suing, aka Jamie Foxx. She has a suit for him against Mr. AKA Jamie Foxx and this Catch rooftop business, and then Mr. Birnbaum. So the owner of this Catch Top restaurant. Statement of facts. Okay, this matter is filed timely as it is brought pursuant to the Adult Survivors Act. Right, because the Adult Survivors Act is, I think tomorrow is the last day. I think it's the 24th, right, the 24th of November is the Adult Survivors Act, New York. So, which states in pertinent part, notwithstanding any provision of law which imposes a period of limitation to the contrary, and the provisions of any other law pertaining to the filing of a notice of claim or a notice of intention to file a claim as a condition precedent to commencement of an action or special proceeding. Every civil claim or cause of action brought against any party alleging intentional or negligent acts or omissions by a person for physical, psychological, or other injury or condition suffered as a result of conduct which would constitute a sexual offense as defined in Article 130 of the Penal Law committed against such person who was 18 years of age or older, or in as defined in section of the penal law committed against such person who was 18 years of age or older, which is barred as of the effective date of this section because the applicable period of limitation has expired, and or the plaintiff previously failed to file a notice of claim or a notice of intention to file a claim, is hereby revived, and action thereon may be commenced not earlier than 6 months after and not later than 1 year and 6 months after the effective date of this section. And any such claim or action, dismissal of a previous action ordered before the effective date of this section on grounds that such previous action was time barred and or for failure of a party to file a notice of claim or a notice of intention to file a claim shall not be grounds for dismissal of a revival action pursuant to this section. Let's get into the details of this lawsuit. The defendant's actions described herein all occurred when plaintiff was over the age of 18 years old. Oh, okay. So it says the defendant's actions described herein all occurred when plaintiff was over the age of 18 years old. But I mean, it said the defendant's actions described herein. So I mean, I don't know if they talked to the defendants, but it said the defendant's actions described herein all occurred when the plaintiff. Oh, okay. So in other words, these allegations happened to the plaintiff when she was over the age. So I guess I would say when Miss Jane Doe was over the age of 18. Yes, she was. The plaintiff was over the age of 18 years old and brought within the time frame of the Adult Survivors Acts above. Right, the Adult Survivors Act. So tomorrow is the last date. It's the 24th. It says on or about August 26th. 2015, right, 2015 at approximately 11 p.m. Plaintiff and a friend arrived at 21 9th Avenue for the purpose of getting seats at the rooftop lounge and bar. Upon being seated, plaintiff noticed that defendant Mark Birnbaum was seated one table away having drinks with defendant Eric Marlon Bishop, aka Jamie Foxx. It said not long after being seated, plaintiff and her friend observed a large crowd growing around defendants Birnbaum and Foxx's table. As a result, defendants Jane Doe's 1 to 10 began moving the crowd of patrons away. So as a result, the defendants Jane Doe's 1 to 10. So in other words, I assume it's 10 defendants that will be named in the lawsuit, began moving the crowd of patrons away, including nearly all of the patrons seated at tables near Birnbaum and Foxx. Despite them being the only two remaining in the area, plaintiff and her friend were never asked to move from their table located beside Birnbaum and Foxx's table. So in other words, Jamie Foxx, aka Jamie Foxx, and Mr. Birnbaum, they were sitting at their table, and a lot of people started crowding around them. So it seemed like the restaurant got busy. So the plaintiff said her and her friend were never asked to move from the table that was located beside Mr. Birnbaum and Mr. aka Jamie Foxx. Just say Jamie Foxx. And at some point near approximately 1 a.m. on August 27, 2015, after many patrons had left the area, plaintiff's friend stood up from the table, walked over to defendant Foxx, and asked if he would take a picture with her and plaintiff. So the plaintiff's friend walked over to Mr. Foxx's table, Jamie Foxx's table, and asked him could she take a picture with him. Foxx stated, sure, baby, anything for you, and walked to plaintiff's table. Several photographs were taken. While taking photographs, plaintiff observed that Foxx seemed intoxicated. At one point, Foxx roughly grabbed plaintiff's phone out of her hand and took additional photographs. Foxx then made several comments to plaintiff, including, "Wow, you have that supermodel body. You smell so good, and you look like Nikki." When plaintiff asked, "Who's Nikki?" Foxx replied, "Gabrielle Union." Foxx proceeded to grab plaintiff by her arm and pulled her to the back area of the rooftop. So these are all alleged allegations. So innocent in the United States, you are innocent until proven guilty. So number 42, once in a more secluded area, Foxx placed both of his hands on the plaintiff's waist, moved them under plaintiff's crop top, and began rubbing her. Plaintiff was caught off guard and attempted to step away from Foxx. Plaintiff noticed defendant John Doe. So plaintiff noticed defendant John Doe, a security guard of one of the defendants some distance away who saw what was happening, walked further away. Foxx proceeded to slide his hand into the plaintiff and put his on her and the plaintiff, and as this was happening, plaintiff's friend walked over looking for plaintiff. Foxx stopped touching plaintiff and walked over to where defendant John Doe, a security guard, was standing. So these are all allegations. This is all alleged. So we would say allegedly, but I mean it's a lawsuit, so I'm just reading what's in it. And so let's go with number 43. That no negligence or intentional acts on the part of the plaintiff caused or contributed to the said heinous touching and of the plaintiff. That by reason of foregoing, plaintiff was injured, was rendered sick, sore, lame, and disabled. It says that by reason of the foregoing, right? The plaintiff was rendered sick, sore, lame, and disabled, was caused to undergo medical treatment and advice, was unable to pursue her usual and regular activities, was caused to undergo great conscious pain and suffering, continue to undergo such, and will permanently be affected by the injuries and emotional distress she incurred as a result of the abuse, assault, and battery. That as a result of the heinous acts, negligence, and gross negligence of the defendants as aforesaid, plaintiff suffered and continues to suffer severe emotional distress and anxiety, humiliation, embarrassment, post-traumatic stress disorder, and other physical and emotional damages. Let's get into this lawsuit. What? Let's get into it. Plaintiff is entitled to recover. Yeah, plaintiff is entitled to recover damages, right? Like I said, this is a civil lawsuit where you can recover money damages. Plaintiff is entitled to recover damages from defendants in an amount that exceeds the monetary limit of all lower courts that will have jurisdiction over this matter, plus punitive damages, right? Punitive damages are set to punish the defendant. So punitive damages is a civil lawsuit. Money damages, and so she's seeking punitive damages. So she wants to punish the defendants. So I think it's 10 of them. I think the lawsuit states that it's 10, but some of them wasn't named. Some of them wasn't. I didn't see, but like 4. But I guess it was the different businesses. I mean, the different, the rooftop business, different locations, different, corporation, and AKA Jamie Foxx, and then Mr. Birnbaum. First cause of action. This is the first cause of action. So we're talking about. So I'm not going to read what the cause of action is, but it's the assault and battery. So it's assault and battery. Plaintiff repeats and realleges the allegations of paragraphs 1 through 47 as though same were more fully set forth at length herein. That on the night of August 26, 2015, and into the early morning hours of August 27, 2015, and at all times herein mentioned, defendant Foxx, operating through his position as a well-known celebrity, committed the heinous acts as set forth above. So they're saying allegedly he committed these heinous acts because he was a well-known celebrity and people would probably just let him do anything. These unlawful actions constitute an battery upon plaintiff as Foxx intentionally and without consent used force to offensively touch plaintiff's person. Right, your person. Anything on your body is considered your person. So somebody could you could be walking down the street or walking somewhere and you can have a pocketbook on your shoulder and somebody can knock that pocketbook off with the intent to harm. But if they knock the pocketbook off accidentally, that would be no intent to harm. So see, most crimes are built on intent. So somebody just forcefully or knock your pocketbook off your shoulder with the intent to harm you, get something started with you. So that is a crime. That is part of your person. That could be also a battery. That is considered a battery too. So you knocked my pocketbook off my shoulder. You intended on harming me. It wasn't like if a person do it accidentally. They say, excuse me, I'm sorry. That is not a crime. So most crimes are built on intent. So intent to harm. So your person is anything on your person. You can have a belt on your pants, holding your pants up, like I said, a pocketbook on your shoulder. You can be holding your keys in your hand, and they could, you knocked my keys out of my hand. You did it forcefully. You did it with the intent to harm. So that's a battery right there also as well. So let's get back into this lawsuit. So let's see, it says it happened August 26, 2015. So it says defendant Foxx, he was operating through his position as a well-known celebrity. So let's move on. So in other words, that's what the lawsuit is alleging. Foxx's actions were willful, wanton, and malicious. See what I'm saying? Malicious, see, with that intent to harm. That is what most crimes are built on. Yes, but we do have other crimes of negligence, so I'll get into those probably in one of my other videos. So you can be charged with a crime. You can be careful enough and something can still happen to someone and then you can be still charged with a crime. So let's go with, but then you have the intent behind a lot of crimes where, you intended on harming that person. You intended on harming that person, you intended on harming somebody's property. So it's just a whole lot when it comes to law. So you have to read into it and try to get a clear understanding. So I am taking a few law courses at this time now, and I also took a business law class with Strayer University. So I do want to go ahead and get my law degree, yes, because I am very familiar with the law. And there's a lot of different areas of the law. I like the, I think I'm taking a course. Well, one of my courses is, I don't know if it's not constitutional law. We were talking about constitutional law in the class, but I think the class is not constitutional law. It is, I think it's international law. I think the name of the class is international law, and then the other class I'm taking is American law. So I'm taking 2 law courses now. Very interesting information, learning a lot. So I'm taking those courses with Coursera.org. So free courses. They have free courses, then they have certificate courses, and they have, you can get your degree as well, but they have other universities around. So I went to Strayer University. I got my bachelor's in business administration, my master's in information systems, but we do have Howard University here in the States. We have Howard University, we have different universities over here, University of the District of Columbia. So let's get into the second cause of action: negligent hiring, training, and supervision. Right. So getting it down. Yeah. So I mean, this is something good to get into and read these lawsuits. Not that you would want to see lawsuits happening to, people that you know, that you love, but it's a great learning experience. So when you read them and get into them and you learn, you're learning. Because the thing is, not only is the lawsuit talking about AKA, Mr. AKA Jamie Foxx, they're naming him as one of the defendants, AKA Jamie Foxx. So Jamie Foxx. Then it's getting down to the business, the assault happened in a particular business. In other words, they have a duty of care to keep their customers safe. So they didn't keep the environment safe, and this alleged assault happened. So, a lawsuit happened. This lawsuit happened against AKA Jamie Foxx and also the business where the alleged, the business and the owners, where this alleged assault happened. So she's suing the defendant, these two defendants. I don't know. I think it looked like it was about 4 different defendants named, but it said 1 to 10. So, but I didn't see all 10. So, but the defendant, 4 defendants so far that I have seen in the lawsuit. So the plaintiff is, suing the business owner, and AKA Jamie Foxx, and Mr. Birnbaum. I guess he's the owner of this rooftop restaurant. So it says second cause of action: negligent hiring. So right, she's attacking. The plaintiff is attacking it all. The second cause of action, your hiring practices, negligent hiring, negligent training and supervision against defendants. Right, here it is right here. Catch New York City and Roof. Catch New York City Incorporated, Mark Birnbaum. Right, so Mr. Mark Birnbaum, and Mr. Jamie Foxx. So the whole business, in other words, they were negligent in hiring. So, so I guess they're going after, I guess the plaintiff is going after, some of the other employees of this said rooftop restaurant. Okay, it says plaintiff repeats and realleges the allegations of paragraphs 1 through 52 as those same were fully set forth at length herein. That the defendants Catch New York City and Roof, Catch New York City Incorporated, Mark Birnbaum, Catch Hospitality Group, 25th 9th Avenue Corp. This is in California. This is 21 through 27, 9th Avenue LLC through their owners. So the owners, managers, supervisors, officers, directors, agents, and or employees were negligent in the hiring. So this is a lawsuit against the whole company. So it says through their owners, managers, supervisors, officers, directors, agents, and or employees were negligent in the hiring. Right, negligent in the hiring. Hiring and training, lack of supervision, management, control, and retention of their employees, and more specifically of defendants. Jane Doe's 1 to 10. I don't know why I said John and Jane Doe's 1 to 10. I assume they're talking about, I guess they're talking about, the lawsuit is talking about 10, naming 10 defendants. Because they're talking about, it says, that's what it says, that the defendants. So these are the defendants. Catch New York City and Roof, Catch New York City Incorporated, Mark Birnbaum, Catch Hospitality Group, 25th 9th Avenue Corp, LLC, and Catch 21, I guess it's California, CA, 21 and 27 9th Avenue, LLC, through their owners. So they're suing the business through their owners, managers, supervisors, officers, directors, agents, employees. They were negligent in their hiring and training. So let me move on. That the defendants Catch New York City and Roof Catch New York City Incorporated, Mark Birnbaum, catch hospitality through their owners, managers, supervisors. Well, they reiterating that again. Through their owners, managers, supervisors, officers, directors, agents, employees were under a duty, right, that's what I'm saying, you have a duty of care. They were under duty to exercise reasonable care for their patrons, including plaintiffs, so as to prevent the intentional heinous acts that Foxx inflicted on the plaintiff. So in other words, you didn't provide a duty of care, and they have a duty to exercise reasonable care for the patrons, for their patrons, including plaintiff, so as to prevent the intentional heinous acts that Foxx inflicted on the plaintiff. I mean, a lot of companies have their security. I mean, where was your security? Things like this was happening. So I wonder, I guess I'll soon, I mean, I was thinking about other cases too, where, in other words, you're dining in a restaurant, and then what if somebody come and shoot up the restaurant while you sitting in there eating? Dude, I mean, they do have a duty of care. You sitting in a restaurant, you're eating, and all of a sudden somebody come in and start shooting and you are injured. So can you get a lawsuit against this restaurant for not protecting you because you sitting in there eating and this person coming in? Or even not only that, they came in and shot up the place, but what if they came in and you sitting there eating and they came in and robbed you of all your jewelry and you had your money on the table because you were about to leave, so you had your money on the table so you can pay for your your food, and then you got robbed sitting right there in the restaurant. So I guess they do have a duty of care. You didn't provide enough, you didn't exercise reasonable care for me as a patron. I'm sitting there eating my food and then I get robbed right in your restaurant. So those are the things that you have to think about. What? Yeah, so look, Deadly Defendants Catch New York City and Roof Catch New York City Incorporated, Mark Birnbaum Catch Hospitality Group. So I just thought of that. And I'm thinking about that. I'm like, you know what? So I did learn a lot of these topics, a lot of these things in my business law course. Agents and/or employees had knowledge of Foxx's propensities for aggressive behavior towards females. Okay, the potential for unwanted actual touching and his bad disposition, when consuming excessive alcohol. So it's like the plaintiff is saying, allegedly, I guess I would say, that Mr. AKA Jamie Foxx was intoxicated. And so they're saying that, people that know him know that when he get intoxicated, these are the type of things that he does do. The above defendants failed to properly train their staff, including defendants John/Jane Doe's 1 to 10, how to properly observe, report, and prevent the situation in which plaintiff found herself, how to observe when a patron such as Foxx has consumed an excessive amount of alcohol and should not be served anymore, and in otherwise ensuring the safety of their patrons from unwanted and abusive touching. Defendants Catch New York City and Roof Catch New York City Incorporated, Mark Birnbaum Catch Hospitality Group, 25 9th Avenue Corp. LLC and CA 21 to 27 9th Avenue LLC. They talk about the owners, the managers, the supervisors, officers. I mean, it seems like the lawsuit is coming against the owners, managers, supervisors, officers, directors, agents, and/or employees, including defendants John/Jane Doe's 1 to 10 failed to use reasonable care to prevent the acts described herein. So I know they didn't say they have a duty of care, but they said they failed to use reasonable care. In other words, they're saying that according to the lawsuit, the owners, the managers, supervisors, or directors, officers, employees, they was not trained enough to be able to see something like this going on and be able to report it in a timely manner and also be able to prevent it. I mean, it's like a lot of times things go on and people, nobody sees anything. Where's the security? Were there other people sitting around eating? I mean, well, no, I think I did read earlier on in the lawsuit where the plaintiff was taken to a secure location. So in other words, probably wasn't nobody around where they could see anything going on. So it says number 59. Let me skip all the way down here. That the defendants in this Catch New York City and Roof Catch New York City Incorporated, Mark Birnbaum, Catch Hospitality Group. It says, in other words, it said that they breached their duty of care. Right, they have a duty of care to plaintiff by failing to provide adequately for the protection of persons lawfully upon, within, and wherein the premises, and more particularly for the plaintiff herein. I can never say that word right there. And failing to protect the plaintiff against injury caused by the conduct of the employees, agents, in failing to provide security, adequate security, and or proper security within the premises. Although they knew or should have known of the dangers existing thereabouts. I never heard that word before. Thereabouts, in failing to operate the premises in a reasonably safe manner in order to protect all persons lawfully upon the premises, in that they knowingly and intentionally place the plaintiff in a dangerous situation and a position of peril, in that they caused, created, and contributed to the dangerous conditions and situations existing on the premises at the time of this occurrence, in failing to supervise and or adequately supervise the activities of the employees, in violating those statutes, rules, regulations, and ordinances governing the management, security, and control of the premises held out to the plaintiff, and in failing to exercise the care, caution, and judgment required of the defendants under all of the circumstances that existed at the time of occurrence and earlier. The defendants, their agents, servants, and employees were otherwise careless, reckless, and negligent under the circumstances then and there existing. Boy, don't you know these lawyers know how to put it together? For real. Yes, that is a good field to be in. Know how to put these type of lawsuits together. So this is a complaint that is very well written, very well written, and I can understand it. I like it when I can understand, So this lawsuit is, start out with a complaint. So basically, it's a lawsuit. So lawsuits you can have a jury trial with a lawsuit as well. But like I said, with lawsuits in a civil lawsuit, they're dealing with money damages, punitive damages, as a result of the actions and inactions of defendants. So I'm not going to read the names again, so we already know that, inactions. And the defendants Catch New York City and Roof Catch New York City, Mark Birnbaum. So, and it says 1 to 10, as described herein, plaintiff has suffered and continues to suffer physical and emotional injuries, anxiety, distress, embarrassment, and economic harm. Plaintiff is claiming and is entitled to recover all applicable damages, including, some money damages, including but not limited to damages for pain and suffering, economic loss, as well as punitive damages. Punitive damages to punish the defendants. It's a plural, so it's more than one. We have Mr. AKA Jamie Foxx, and we have the business, rooftop business, and Mr. Birnbaum. So it says, including but not limited to damages for pain and suffering, economic loss, right? Economic loss, probably couldn't go to work, pain and suffering. And it says punitive damages in an amount that exceeds the jurisdiction of all lower courts. So they're seeking an amount that exceeds the jurisdiction of all lower courts. So they're looking for a large amount. Third cause of action, violation of the Victims of Gender Motivated Violence Act against all of the defendants. Plaintiff repeats and alleges the allegations of paragraphs 1 through 61 as though same were fully set forth at length herein. The unlawful conduct of defendant Foxx, as described herein, including but not limited to Foxx's physical and of the plaintiffs in New York City, constitutes a crime of violence and a crime of violence motivated by gender against plaintiff as defined by the New York City VGMVPL. The unlawful conduct of defendant Foxx, as described herein, including but not limited to Foxx's physical on the plaintiff in New York City, constitutes a crime of violence and a crime of violence motivated by gender against plaintiff as defined in the term crime of violence means an act of series of acts that would constitute a misdemeanor or felony against a person as defined in state or federal law, or that would constitute a misdemeanor or felony against property as defined in state or federal law if the conduct presents a serious risk of physical injury to another, whether or not those acts have actually resulted in criminal charges, prosecution, or conviction, and the term crime of violence motivated. So let me see, look at this pop-up off of here. So motivated, the term crime of violence motivated by gender means a crime of violence committed because of gender or on the basis of gender and due, at least in part, to an animus based on the victim's gender. So I never heard that word before. I have to look that word up. Animus. ANIMUS. Based on the victim's gender. Defendants, so they talk about the defendants again, 1 through 10, enable Foxx's commission of the crime of violence motivated by gender and are therefore also liable under the VGM VPL as a direct and proximate result of the aforementioned crime of violence and gender motivated violence. Plaintiff has sustained and will continue to sustain monetary damages. Yeah, plaintiff has sustained and will continue to sustain monetary damages, physical injury, pain and suffering, and serious psychological and emotional distress, entitling her to an award of compensatory and punitive damages, injunctive and declaratory relief, attorney's fees and costs, and other remedies as the court may deem appropriate damages as set forth. The unlawful conduct of defendant Foxx, Mr. Jamie Foxx, as described herein, constitutes an offense as defined in Article 130 of the New York Penal Law. Pursuant to this cause of action is timely because it's commenced within 2 years and 6 months after September the 1st, 2022, as a result of the actions and inactions of all defendants as described herein. Plaintiff has suffered and continues to suffer physical and emotional injuries, anxiety, distress, embarrassment, and economic harm. So she's facing economic harm. In other words, you have to go through this, mental distress, mental anguish, pain and suffering. You're going through it mentally, and you can't go to work. There's also, economic suffering. So how can you work when your mental state is, not in the right place? You're mentally not competent to even work because, you've been through so much. You've been through something that someone else put you through, So, okay, let me see. So where did I stop? Okay, number 70. Plaintiff is claiming and is entitled to recover all applicable damages, including but not limited to damages for pain and suffering, economic loss, as well as punitive damages in an amount that exceeds the jurisdiction of the lower courts. So they're seeking amounts And so they are seeking, so the plaintiff, she's seeking, her and the lawyers, they're seeking an amount that exceeds the jurisdiction of all lower courts. Wherefore, plaintiff demands judgment against the defendants hereon on all causes of action in a sum exceeding the jurisdictional limits of all lower courts which would otherwise have jurisdiction, plus punitive damages where permitted, together with the cost and disbursements of this action. So that's the lawsuit. So like I said, this is like the lawsuit states, this is a complaint. So the defendants will have to, have their lawyers look this document over, this complaint, this lawsuit. So the defendants will have to have their lawyers, look this, the summons. I guess they received it first. So in other words, if plaintiff filed a complaint, and then so once once the defendants, receive their summons, so they have to make sure they have their, appoint their lawyers. Their lawyers have to look things over, and then I guess they'll take it from there. So I don't know if they're going to settle like Puppy Combs did, Puppy Combs versus Miss Cassie Ventura. So I don't know if they are going to, if these defendants are going to settle. So we have to see how things are going to play out. But these are all allegations at this point. So a lot of times, just like a criminal case, you can have you can also have a trial. They would also have a trial if they go forward. If they don't settle, then they will have at the same time they can I guess request a jury trial. And jury trial, so is they would be seeking money damages, but they still can have a jury trial just like a regular criminal, a criminal case. But this is not a criminal matter, this is a civil lawsuit. So civil lawsuits, the plaintiff seeks money damages, punitive damages, like I said, compensatory damages. So seeking damages to, punitive damages to punish the defendants. So it's a lot being said in this lawsuit. I just want to jump in here and, I want to just, read through the lawsuit and see what was in it. What were the claims? What were the allegations? That is what I wanted to see. So in other words, this rooftop cafe, this rooftop bar, Catch New York City Incorporated, Mr. Mark Birnbaum, and Mr. AKA Jamie Foxx. So they all, being named in this lawsuit. So they didn't offer a duty of care. They didn't offer reasonable care. They didn't train their employees, supervisors, managers to be able to see something like this, a situation like this, an assault like this, an alleged assault like this take place, and then didn't do nothing about it. Because I'm like, where were the security? Where was the security for the business? So all these are all alleged allegations at this point. So just wanted to read through this lawsuit, this lawsuit from Miss. So they don't have the name of the plaintiff, that the person that is suing, the person that initiated this lawsuit. They just have Jane Doe. So we have Jane Doe, I think, and John Doe. John Doe, I think it was, John and Jane Doe's. So in other words, the plaintiff. The plaintiff is the person that is suing, seeking damages. So that's Jane Doe. So Jane Doe is the person that seeking, money damages through this civil lawsuit. So that's the Jane Doe. So they look like they got, they have plural. They have John and Jane Doe's. John and Jane Doe's. But I didn't see but one. The way they have it written, it looked like, it said John / Jane Doe's. So we have Eric Marlon Bishop, aka Jamie Foxx, Catch New York City Rooftop, Catch New York City Incorporated, Mark Birnbaum, Catch Hospitality Group, 25th 9th Avenue, Corp, LLC, CA 21 to 27, 9th Avenue, LLC, and John/Jane Doe's. But I didn't see, well, it only say one Jane. You know, well, I mean, sometimes I don't know if that's a misprint or what. But I know it's more than one John Doe. It's John Doe's plural. So John Doe's is, you know, because you can see it right here. See the plaintiff. The plaintiffs are Eric Marlon Bishop. I mean, no, the plaintiff is John Doe. The plaintiff is John Doe, and these are the defendants. The defendants are Eric Marlon Bishop, aka Jamie Foxx, Catch New York City and Roof, Catch New York City Incorporated, Mark Birnbaum, Catch Hospitality Group, 25th, 25 9th Avenue Corp LLC. Then we have 9th Avenue LLC. So, you know, it's several defendants. So let's put it that way. Several defendants, and I see one Miss Jane Doe. But we'll just have to see how this lawsuit plays out. So we don't know if it's going to be settled, or we don't know if they're going to take it to trial. So we have to, you know, I'll keep you updated. So I'll be keeping, you know, up with this lawsuit. So I'm not going to hold this video too long, because that's an hour. But, so, you know, subscribe to this video. Like this video. What? Like this video. Follow my channel, Shirley TV. And I also have TV1 Productions. See, Shirley TV, TV1 Productions, and Brainstorm Entertainment Productions. Then I also have a cooking channel. But these two channels are the ones that I mostly post on. Shirley TV and TV1 Productions. So just look for those two channels right there. But I want to say thanks for joining me. Glad to see you. Glad you could be here. I want to say happy Thanksgiving again. So I just wanted to look through this lawsuit and see exactly what was in it. I wanted to see what these allegations were. You know, so yes, so I'll keep you updated. So I just wanted to see, you know, what was in this lawsuit. So we have to see how this thing is going to play out. We'll have to see how it's going to play out. Will they settle? Or, you know, will they come out and make a statement? What? Will Jamie, Mr. AKA Jamie Foxx, come out and make a statement? But 9 times out of 10, they may not, you know. So once they acquire their lawyers, a lot of times the lawyers may tell you, you know, don't go say nothing. So then we don't know if it's going to be, you know, in other words, we don't know if it's starting from a civil situation, then it turns into a criminal situation, because these are some criminal allegations in this lawsuit as well. So, criminal allegations. So, you know, but I'm not going to read back through the allegations. So I guess, you know, if you want to further look at this lawsuit, you know, check it out online. So I found it on, you know, New York, it says state-newyork.us. But it says https://iapps.courts.state.ny.us. So I mean, you can find it. I found it. I don't know. I think I did a Google search. But if you can find it, you know, you feel like you want to read through it, you know, that's cool. But, you know, so I want to close out on this video right now. And I want to say, hope you all have a happy Thanksgiving. Don't eat too much, though. What? Have a happy Thanksgiving. And I'll see you on my next video. So, goodbye. Yes. Have a good one.